Good morning, everyone. Thank you for attending today's webinar on sponsoring overseas workers for your hospitality business. First, I'd like to direct you to the Employer Guide to Sponsoring Foreign Workers, which is our publication. You can click on the QR code or you can access it via the website link. I'd like to start with an acknowledgement of country first, which is we acknowledge and pay respect to the past, present, and emerging traditional custodians and elders of this nation, in particular the Gadigal people of the Eora Nation, whose land our Sydney headquarters is situated on, and the various lands on which those of you are joining us. So I'd like to introduce you to your presenter speakers today, which is myself, Yin Chiew. I'm the practice leader of the corporate immigration team, and Karthiha, who's a lawyer in the corporate immigration team too. We're so pleased to have you here today and to join us. And I'll start with a few kind of housekeeping announcements, such as you will receive a recording of the slides in your email. And you can submit your questions in the chat box during this webinar. I note that some of you have already sent some questions, so towards the end of the webinar, there will be time for question and answers, and I will do my best to go through all of your questions as well. But if you think of any new questions while the webinar is proceeding, please feel free to put your questions in the chat box. And please complete the feedback survey after the webinar. That survey will be provided in a separate email, and that will be sent to you after the webinar. So to give you sort of an idea of this webinar, it is very much for informational purposes only, and it's typically not designed to provide complex or tailored legal advice. But as part of registering for this webinar and attending, you will be able to claim a complimentary consultation with the corporate immigration team if you complete the survey and you claim that consultation within 48 hours of the completion of the webinar. So if you'd like to receive a more tailored, specific legal advice to your current situation, feel free to complete the survey and let us know that you'd like a complimentary consultation, because this webinar will probably go through a lot more broader general information on how to sponsor workers for your hospitality business.
So to give you a brief idea of the topics that we'll be discussing today, we'll be talking about the proposed and upcoming changes to migration. We'll be discussing the relevant ANZSCO occupations, caveats, and visa pathways in the hospitality industry. And we'll also be discussing general business eligibility and implications of sponsorship. At the end of the webinar, as Yin said, we'll be answering some of your questions. So don't forget to submit some of your questions in those in that chat function, and then we'll try to address as many as we can at the end. Now I'll pass it back to Yin.
So there's going to be a lot of changes in the employer-sponsored space. And as you may be aware, the federal budget was released yesterday. And in relation to the migration law landscape, the focus for the migration planning will be on employer-sponsored visas over and above any other visa program. So the planning levels have increased dramatically. There will be significant changes to the employer-sponsored visa program, which we know it as the subclass 482. Towards the end of last year, more specifically the 11th of December, they did want to introduce a new skills in demand visa. There were discussions around replacing the subclass 482 or making it a sort of a different structure that encompasses 3 pathways, which is the specialist skills, the core skills, and the essential skills. And that hasn't yet eventuated, it hasn't yet been implemented into legislation. These are merely proposals at this stage. And then with the release of the federal budget yesterday, it did also stipulate that there would be changes to the work experience component of the subclass 482. As we will go through the webinar, you will see that typically the work experience skills requirement for a subclass 482 is 2 years of full-time work experience in the nominated occupation or related field. And the proposals of the federal budget stipulate that that will be reduced from 2 years to 1 year towards the end of this year. So with those changes in the work experience, with the introduction of these 3 specialist pathways, there's current stakeholder consultation taking place with the range of different businesses. So as a hospitality business, if you're particularly concerned about how the employer-sponsored visa program will impact your business and whether you can sponsor the types of skills that you need, the Department of Home Affairs and the relevant government agency will be accepting submissions from relevant stakeholders up until the end of this month. And that's quite important because they are preparing what's called a draft core skills occupation list. And there are currently some occupations that will remain on the occupation list. And there's other occupations that they're not sure that will remain on the list. And that's the basis of the consultation. And it could actually impact hospitality businesses because some of those occupations are chefs, cooks, pastry cooks, those sorts of occupations that you would typically find in a hospitality business. So if you want your voice to be heard, it's very important to put forward a submission or see if there's a way that you can, explain to the department that those occupations are very pertinent and essential. So just a reminder that that consultation process will complete at the end of this month. So we've received quite a lot of questions, and always the main question is things like, well, how do we sponsor a foreign worker? What's the most simplistic? What's the most straightforward way? What should we consider? What's the most cost effective? And the short answer to that question is that it isn't a simple process, unfortunately. And usually it starts with assessing first the business and what it does and its viability to sponsor. And then the second part is assessing, well, what is the actual occupation? And that is the key here. The occupation will actually inform the appropriate employer-sponsored visa pathway. And we have provided this very simple, though lengthy table, so read it at your leisure, that kind of outlines the typical occupations that a range of hospitality businesses may require and may need to sponsor. And then as a result of that, that then identifies the type of employer-sponsored pathway. So as you can see here, if I take the first occupation, for example, chef, it is available for a hospitality business to sponsor on the subclass 482 under the standard employer-sponsored pathway, also with the 494, which is a regional employer-sponsored visa. There will be permanent residency options from the 482 via the subclass 186, and there are a couple of different streams under the 186. The RILA is the Restaurant Industry Labour Agreement, and the DAMA is a regional labour agreement, but that will be specific to the actual locale. So as you can see here, it can be quite complex in that for some skills and occupations, there could be a variety of choices. And then identifying the appropriate pathway will be based on a number of factors that is unique and pertinent to the business, such as, well, is the applicant over a specific age? Does the applicant want permanent residency straight away? Are we based in a regional location? Or is this an occupation that we can only sponsor in a regional location? Or is there any permanent residency options available? So a lot of those key questions will inform the pathway that's appropriate. And obviously that will be part of our initial assessment and discussion with you to help you develop, to help you identify that solution for your business. But this is just a very broad snapshot of the types of occupations and what could potentially be available in terms of employer sponsorship. And then it's an assessment of, well, which one is suitable for your business. So I will then revert this back to Karthiha, who will talk to you about these applicable caveats on the occupations.
Thanks, Yin. So occupation caveats are specific requirements that are attached to some ANZSCO occupations. They are designed to ensure that skilled visa programs are used to fill skilled positions that cannot otherwise be filled in the local labour market. So if a caveat does apply to an occupation that you're intending to sponsor, you will need to explain this and substantiate how this is satisfied. And this will usually occur at the nomination stage of whatever application pathway you're pursuing. If a caveat does apply, there are no exceptions to this, but the department will exercise their discretion and assess your case that you've put forward and your evidence that you've put forward in assessing whether that's met or not. And it's also important to note that the caveats are only applicable under the 482 and 186 visa pathways. They're not relevant to 494 or the labour agreements that Yin mentioned. As you can see on this slide, there are a few ANZSCO occupations listed with either one or both of the main caveats being applicable. So you can see that there are two main caveats, one being that the position cannot be based in a mass production or factory setting, and the other being the position cannot be based in a limited service restaurant. So one or both will apply, and this will completely depend on the ANZSCO occupation that you're looking to satisfy. So just to explain further on the first caveat, so this is meaning that the position cannot be based in a mass production or factory setting. So an ANZSCO occupation that is an example that this applies to is a baker. So the department provides some general information to inform how they assess whether this caveat is met. So the position cannot be based in a franchise or factory. It cannot involve full or partial production of food for distribution to other locations. And it cannot predominantly involve the use of pre-prepared food from other locations. So there are a lot of considerations that the department will take into account when assessing if the caveat is met. It's a balancing act. They may not all be relevant. So it would depend on a case-by-case basis. On the left here, we've got some considerations that will conflict with the caveat. So are there large production quantities being made for the products being offered? Are there pre-mixed ingredients? Is there a significant use of machinery or an assembly line in place? Are there repetitive tasks being completed? These factors are indicating that there is a production line setting happening. Is there a limited range of products? Is there use of pre-prepared, frozen or delivered products? And are the employees that are employed little to no skills, or are they qualified with a lot of expertise? On the right here, we've got some opposing considerations that will help to satisfy the caveat. So one is whether the business is holding a specialist setting. So for example, a commercial kitchen that sits out the back of a front end bakery and all the products are being made from scratch in the back on the day. Converse, in addition, the marketing format. So are the products actually being marketed as, for example, being freshly baked in the store? Is there a comprehensive range of products being offered? Are they marketed as organic and gourmet, high end? Are they baked and handmade from scratch? And if the business is involving wholesale, is there distribution to cafes or restaurants as opposed to supermarkets, which is likely alluding to whether the products are fresh with short lifespans or can sit on a shelf for months or years. So this is not an exhaustive list, but the key difference we're seeing here is production settings and lower skills being required to prepare products versus really curated, fine-tuned products that require a high level of expertise or qualifications. So moving into the second caveat that could apply, this is that the position cannot be based in a limited service restaurant. So an example of an ANZSCO occupation that applies here is a cafe or restaurant manager. The department has provided some general information again around how we can assess this. So they've said that that limited service includes fast food or takeaway food services, fast casual restaurants, cafes with limited food service, coffee shops, more cafes, things like that, but it's not an exhaustive list. And again, there are several considerations that the department will take into account, and they'll balance all of these considerations. In some situations, it will be very obvious whether the caveat is met or not. So a clear example would be McDonald's being a fast food chain. It likely will bring about all the characteristics that conflict with the caveat being met and showing that it's limited service. But in other situations, it might be nuanced, and we need to really assess it, assess the nuances of the situation. So here on this slide, we've got a range of characteristics that will be assessed. So is full table service being offered? Is there payment being made before or after eating? How much seating is there? Is the business designed in a way that invites someone to come in and sit, or is it more of a takeaway style kind of business? Is it marketed as being a fast food, fast casual restaurant? Are the food characteristics, other characteristics of the food being speed and convenience, familiarity, predictability of the food, or is it more associated with being complex dishes that will take 40 minutes to make, that you have to sit in the restaurant to experience that product that's being offered? How is the food being presented? How long does it take to make? Is there a commercial kitchen that's being involved, or is it more, a sandwich that's being assembled at the back of a cafe counter, for example? And also how the employees and the business is being placed in the industry itself. So is the restaurant being recognized as a Michelin star restaurant in their industry, or are the employees being paid in accordance with an industry award, modern award that requires fast food employees to be paid a certain rate? So lots of considerations here to assess, and it really is a matter of weighing up those considerations, and looking at the products being offered, how they're being offered, and what the customer's experience is really like. And yeah. So now I'll pass it back to Yin, who will talk about the employer-sponsored and nominated pathways.
Thanks, Karthiha. So you can see there's quite a lot. And I just wanted to reiterate that the caveats do apply to some occupations, not all occupation, and it's typically in relation to the traditional employer-sponsored pathway, which is either the subclass 482 or the subclass 186, which is the permanent residency component. And after those considerations of what is the occupation, does any applicable caveats apply, there is then an assessment of what is the appropriate employer-sponsored or nominated pathway. And this is just a very simple flow chart for you to understand what the process would be if you decided to pursue this pathway to nominate or sponsor a foreign worker. And so with the subclass 482, it is a employer-sponsored visa. The subclass 494 is the regional employer-sponsored visa. So the key difference between both is that the 494 requires the business and the position to be based in a designated regional location. The 482 does not. They both also have different, although some overlapping occupations as well. But the typical process is that the Australian hospitality business will need to apply to become a standard business sponsor. And then depending on the occupation, depending on where the business is located, then you may consider the 482 or the 494. The 482 is subject to caveats on specific occupations. The 494 is not. So Karthiha spoke a bit about the caveats such as limited service restaurants that essentially excludes all fast food organisations. It is possible if your establishment is considered a limited service restaurant and you're based in a designated regional location, provided that all the other requirements are met, the 494 could very well be an option. But this is obviously only if the business is based in a regional location. And so moving on to the next slide here, then there are pathways to permanent residency from the 482 and the 191. And there were significant changes towards the end of last year that allowed for all ANZSCO occupations and those that were sponsored on a 482 visa to access permanent residency via the 186 TRT stream after 2 years of sponsorship. And then the 494 has its own pathway to permanent residency, which is the subclass 191. The key difference is that the 186 still requires employer nomination. The 191 does not. In some instances, some occupations may be able to apply or be nominated for permanent residency directly without having the need to be sponsored on a 482 visa first. And this is under the direct entry stream. This is also employer nominated. However, it will depend on the skills of the applicant and whether they have a skills assessment. And obviously, it will be a decision for the business whether that's something that they want to do instead of pursuing the temporary employee-sponsored pathway. And there's many considerations such as the cost, the time frame, the commitment of the employee to remain with the business for a certain period of time before they agree or they decide to nominate the employee for permanent residency. So a lot of considerations that you would need to assess and obviously discuss with your legal advisor about. So Karthiha will go into a bit more detail about the Restaurant Industry Labour Agreement and the DAMA, which are labour agreements essentially. This is a type of employee-sponsored pathway as well, but instead of applying for a sponsorship application, the Australian business, if this is suitable, would need to request a labour agreement from the Department of Home Affairs. And it utilises the standard employee-sponsored pathways, meaning they will still utilise the subclass 482, 494, and the 186. But the terms of the sponsorship will be outlined specifically in that labour agreement, which is a contract between the Australian business and the Department of Home Affairs. It's actually a tripartite agreement between the Minister of Immigration and Multicultural Affairs, the Department, the Minister for Education and Employment, and then the actual Australian business as well. And Karthiha will talk a bit more about the specific labour agreement that relates to hospitality businesses. And then there are a number of DAMAs, depending on where the business is located, where it is possible for you to access. And they typically do provide some differentiation to this standard employee-sponsored process, such as there aren't any caveats that apply. There may be subject to, or there may be age concessions available. There may be salary concessions. There may be concessions to the experience and skill level as well. So I'll let Karthiha explain that to you in a bit more detail.
Thanks, Yin. So we'll first talk about the Restaurant Premium Dining Industry Labour Agreement, which Yin referred to as RILA. So RILA is one of 9 industry labour agreements that are in place in Australia. These usually are a consequence of several businesses within one industry approaching the department and requesting for a specific labour agreement to be in place to be tailored to the industry itself. They will usually have to indicate and actually substantiate that there are extensive labour shortages happening in that industry, and they've consulted with relevant stakeholders that are important in that industry, and they require this. So luckily there is one for premium dining restaurants, and in that industry labour agreement there is fixed terms and conditions that that would be applying to you if you were to become a party to this labour agreement. So as Yin said, you can sponsor under the 482, the 494 and the 186 standard pathways, just in accordance with this specific industry labour agreement. And you can see that there are specific ANZSCO occupations that are available under this labour agreement, which it's not everything, it's just chef, cook, cafe or restaurant manager and trade waiter. And really, if you're interested in sponsoring under one of these occupations in this labour agreement, there are relevant considerations that you need to satisfy. It's not for everyone. There's a lot of criteria that you need to meet. So this generally on the left here, we've got some criteria, which is pretty much indicating that your business needs to be of a higher caliber in terms of it meeting the general characteristics of a fine dining or premium dining restaurant. So there is an elevated standard expected here, and that will be in terms of the actual products and services that are offered within your business or your restaurant, the skill levels of staff, so being qualified and highly experienced chefs and cooks, including waiters and service staff, and also the revenue that's being made. So there are lots of different criteria that you need to show to be able to access this restaurant labour agreement in the first place. And you can always have someone to assist you in assessing whether you can satisfy that criteria. And I guess a key element is not being a franchise. So you can't be a franchised premium dining restaurant. You kind of have to operate independently. On the right here, we've got some stream features, which alludes to what Yin was mentioning before. So there are various English experience and age concessions available, which may make it an easier pathway to access for certain candidates. It allows for the 4-year 482 visa, which may not otherwise be available under the standard pathways. There is permanent residency pathways available after various years, depending on the occupation. And it also allows for the occupation of trade waiter to be sponsored, which is not actually available under the ANZSCO framework at all. So this is the only labour agreement in hospitality that would allow for this. So moving on to the second type of labour agreement, this is the Designated Area Migration Labour Agreement, so the DAMA. So as Yin mentioned, this is something that is regional and location based. So whether you can access this will completely depend on the location of your business. So there are additional requirements that need to be satisfied here. The business must be operating for at least 12 months to be able to access this. There will be pre-approved concessions that are available under each DAMA, but it really depends on your area and what those concessions are. So the first starting point would be understanding your postcode and if that falls under one of the 12 DAMAs that are in place. And then you would be looking at the actual ANZSCO occupations that are available and offered within that DAMA specifically. And then you would be looking at the requirements that must be met on the business side, the position side, and the visa applicant side. And if all of those things can be ticked off, then this would be a really good option for you. So it really depends on a lot of things. But for example, there are benefits to pursuing a DAMA in that they offer a broader range of occupations. So sometimes these occupations will not offer any visa pathways under the standard framework. And additionally, there are positions that are not actually defined by ANZSCO at all that will be captured within some of these DAMAs. So for example, the Kimberley DAMA will allow you to sponsor a bar manager, and bar manager is not captured under ANZSCO at all. So there is flexibility that is offered by pursuing this, but the starting point is whether you fall under one of the DAMA areas. So as Yin mentioned, there is several steps to the labour agreement. And the first thing would be getting approval and endorsement from a designated area representative. And then the second thing would be actually requesting a labour agreement with the Department of Home Affairs. So there is no specific fee or government fee associated with this because it's not an application, it is a request. But once you lodge this, you will be able to sponsor workers in those ANZSCO occupations that are available under that DAMA via the 482 or the 494. And that will be in accordance with the nomination allocations that are offered to you and approved in your labour agreement with the Department of Home Affairs. Most of the DAMAs do have a range of hospitality occupations that are available under them. And again, they expand well beyond the typical occupations that sit within the standard pathways. There are lots to choose from. And you will just need to assess whether they're applicable to you. And here we can see that the 186 visa is available. So you would be requesting a deed of variation to your labour agreement after a few years. And that would allow you to have nomination allocations for workers that are sponsored on the labour agreement seeking to be sponsored for permanent residency. Yes, so now I will move back to Yin, who will discuss general business eligibility and the implications of sponsorship.
Thanks, Karthiha. So another important assessment consideration that we conduct, because each pathway will warrant you to satisfy certain criteria or initial eligibility about your business. So as Karthiha mentioned, with the labour agreements, it is quite important that to satisfy requesting a labour agreement, the business has been in operation for at least 12 months. It's quite different under the standard employer-sponsored pathway in that the business could be relatively new in terms of operation, but you need to establish that longer period of lawful operation in respect to labour agreements. The majority of the roles that you need to sponsor for any employee-sponsored visa does need to be on a full-time permanent basis. So if your business, which is quite common in the hospitality industry, is comprised of a workforce that are casual, part-time, that are not full-time employees, and you're hoping to replicate that in terms of employee sponsorship, that is unlikely to be permitted. So you'll need to consider which occupations or which roles you do need full-time. There needs to be a clearly defined ANZSCO occupation. So we have outlined quite a few that would be applicable, and there can be some overlap sometimes with some occupations, and for example, chefs and cooks. And if you need to satisfy the caveats, then the business will need to meet those caveats of not being a mass production setting or a limited service restaurant as well. So going on to the next slide, depending on which employee-sponsored pathway is appropriate for your business, the business will be subject to complying with sponsorship obligations. And this will pertain to standard business sponsorship, sponsorship under a labour agreement, such as the restaurant industry labour agreement. And those key sponsorship obligations relate to ensuring equivalent terms and conditions of employment with your foreign and your Australian workers, making sure you keep accurate records, making sure that you legally pay for the cost of the sponsorship that you are responsible for, and notifying the department of certain events that occur. Obviously, non-compliance can be quite grave to a business, not only towards its public image, because such non-compliance tends to be broadcasted, publicly made available information on the Australian Border Force's website. But it can lead to penalties, it can lead to sanctions, depending on the situation, depending on the gravity of it, depending on whether there's repeat non-compliance. So very important that once you are approved as a sponsor, your obligations start and you should be aware of them. So moving on to the next slide, which brings us to the end of the webinar. As you can appreciate, that was a lot of information to cover, and I understand that there's quite a few questions, so we're going to get to that in a moment. I just want to remind everyone there is a publication that LegalVision has prepared called the Employer Guide to Sponsoring Foreign Workers, and all you need to do is scan the QR code and you'll be able to obtain a copy. And then I just want to also let you know about our next webinar that's coming up on safeguarding vulnerable clients, mandatory NDIS and in-home aged care reporting. So very relevant, very important to our aged care NDIS industry. And that will take place on Thursday, 23rd of May at 11 a.m. Australian Eastern Standard Time. So you can register at the link in the slide there. So I'll give you some time. If you have any additional questions, to please put them in the chat box. And I think that there are a few that were already sent before that I'm going to answer. But while you are thinking of your questions and doing that, I wanted to let you know about LegalVision's membership service. The membership service allows you access to over 100 experienced lawyers across all our practice areas. And for a lot of practice areas like commercial contracts, trademarks, employment, that will allow you to unlimited document drafting and review, unlimited advice consultation that also includes the corporate immigration team, your own in-house lawyers, which is 100+ lawyers, and an affordable fixed monthly cost. So it will help you with cost certainty. You can also then claim your complimentary legal health check. And don't forget that because you've registered for this webinar and specifically as pertains to this topic, you'll be able to claim a complimentary consultation for us to assess what appropriate employer-sponsored visa options are available to your business. Okay, so let's have a look at the questions. And I'll just see if there's any more questions that have come through. Nothing in the chat so far, but let me go through the pre-prepared questions. Just bear with me a second as I find them. Excuse me. Okay, here they are. Okay, so there were a lot of questions around the most efficient way to sponsor a foreign worker, typically what the costs are, can a business sponsor a chef, what the process is. And I believe that's been generally answered in this webinar. So if you can go through the webinar, you'll also receive a recording. You will be able to sort of see that it's not a simple answer. We do have to understand what your business does, where it's located, what's the occupation position, does the person or candidate that you want to sponsor actually meet the skills requirement? And then we perform all that assessment and we may have to look at some documentation as well, but that's all conducted on a complimentary basis. So if you want to get in contact with us, we can do that and provide you with that tailored advice. And then we'll be able to provide you with a more accurate cost as well, because sometimes the cost varies for employer-sponsored visas, depending on how many years you want to sponsor the applicant for, and then whether there are any additional family members that the applicant wants to include in their sponsorship application. So let me look at some of the other questions. So I have one which is looking to sponsorship trade-off cost versus number of staff requesting sponsorship. Also looking at the process and following the simplest path without involving unions. So I believe with that might be in a business in a different industry, and there's definitely a way to not involve the unions. So I understand this is a little bit off topic, but I've noticed that there's some questions from our health industry clients and attendees. And with some of the pathways that do require union involvement, it can be quite onerous. So there is a way to do it, but I would need to explain that to you in a bit more detail and understand whether certain situations apply to your business. So if you want to get in contact, I can definitely explain that to you a bit further. So let's have a look. There was another question here about what options are available to sponsoring overseas work in terms of food industry, in particular for fast food takeaway businesses? So very good question. And from what I have read in the past, the sponsorship excludes takeaway businesses. However, what if the nature of the business selling points is Asian cuisine, which is not taught in culinary schools? So you're correct. There originally used to, or historically used to be, a fast food industry labour agreement, but that was abolished quite a number of years ago now. And that actually did allow a lot of fast food restaurants, organisations like McDonald's to sponsor workers in their organisation. There is no such labour agreement anymore, and the only labour agreement is for premium fine dining restaurants. It doesn't exclude those types of businesses that are based in regional locations. So they may be able to still access the skills under a DAMA or under a subclass 494. But unfortunately, if the business that is in a fast food or takeaway service only business is not in a designated regional area, is in a metropolitan area, there are very limited options, unfortunately. There may be other work visas that don't require employee sponsorship, but that will be dependent on whether the applicant, the employee that you currently have engaged is eligible for an independent work visa. There's again a few questions about the cost, so feel free to reach out to me regarding the cost as well. Let me just see if there's anything else. I think that's all the questions so far. Let me just find out if there's any more questions. Oh, there's some questions in the Q&A box. Sorry, thank you so much, Emily. I'm still, okay. So the first question is, I understand the importance of the staff being full-time, but if they are currently employed on a part-time basis because they are on a student visa at the moment, are there any options to still sponsor? Absolutely, Sam. There certainly is options to sponsor. The criteria for the employer-sponsored visa is that the nominated position is to be undertaken on a full-time basis. It doesn't actually matter that the incumbent that you want to sponsor has been employed on a casual, part-time or full-time basis before. It is important, their work experience, whether it's on a part-time, casual, or full-time basis, it's more assessed in terms of whether they meet the experience, skills, qualification component of the employer-sponsored visa. But that's quite common for a lot of clients that we work with, and particularly common in the hospitality industry because, you know, most of them are on part-time or maybe they're casual, those sorts of things. The next question is, can you help us on a training visa? Yes, absolutely. We do many training visas across many different occupations and industries. Feel free to reach out to us. We'll talk to you about what's involved. It's definitely a possibility. The duration of the training visa would depend on the occupation that you want to nominate for the purposes of training. And it all depends on a very tailored, specific, thorough training plan, which LegalVision assists in the drafting of. How much are you charging for assistance with a labour agreement? It depends on the labour agreement. So there will be industry-specific labour agreements. There's company-specific labour agreements, the DAMAs may be involve more work because there's already been a head agreement drafted, but feel free to get in contact with us and we can give you the specific amount after we conduct a preliminary complementary assessment. Is the reduced 1 year required experience change going to apply to all occupations in the 482 list? And is this change in effect now? It is not in effect now. There are proposals to introduce it later this year. So this was only just announced yesterday with the release of the federal budget. The intention is to probably amend or update the skills component towards November, December of this year that will see changes. Does it apply to all occupation lists? It may apply to all occupation lists, although we don't know this yet. And the occupation list for the subclass 482 is still under consultation as well. So there is more information that we'll know from now until later this year. Okay, the next question is, from your description of the cafe restaurant manager position, it sounds as though unless you're a fine dining restaurant, you won't qualify. How would a cafe qualify? It depends. I mean, as Karthiha explained, because that occupation has that specific caveat of not being in a limited service restaurant, what that typically means is that the actual preparation of the product and food is not something that doesn't require a higher skill set. So there is actually some thought planning to the menu, there's thought planning to the preparation of the food. You're not reheating things. So it doesn't necessarily mean that a cafe restaurant manager can only be based in a premium fine dining restaurant. It will depend on the nature of your establishment, and that will come down to a very comprehensive assessment on how you prepare the food in your establishment, and then the variety and range of food. So if we're looking at a comparison with some fast food industries where they might buy products in bulk and they may actually just reheat it or do minimal preparation, then that is the issue. That would be an establishment that wouldn't satisfy that caveat. But cafes can be different. But if you want more information around it, feel free to contact us and we can take a more comprehensive assessment for you on a complimentary basis. So we've got a bit over time, and thank you for all the wonderful questions. I know that, we didn't, there may have been more questions, or you might need to know more, or after answering the questions, you might have more questions. So as a result, don't forget to claim your complimentary consultation as long as you complete the survey and then register your interest in that complimentary consultation within 48 hours of the webinar. We'll get back in contact with you. We'll have a more thorough conversation with you around it. And then if there is a solution pathway that's available, then we can advise you on the appropriate costs. But thank you very much, everyone, for attending. We really appreciate it. Have a wonderful day.
Thank you, everyone.